You just got arrested for domestic violence. You are scared, you are shocked, and you know that the allegations are not true. They do not have the full story. And now your lawyer is telling you right out of the gate, take it to trial. But is that really the smartest move? In this video, I will walk you through exactly how that decision should be made in a domestic violence criminal case so that you can decide for yourself if trial really is the right call for you at this point. My name is Veronica Barton. I'm a domestic violence criminal defense attorney here in California. I help people throughout the entire state of California put their cases behind them so that they can enjoy their lives and their freedom. Every case is different and there are no guarantees, but for clients who signed on with me and whose cases were resolved last year, over 95% of them avoided a conviction, and 100% of those who got arrested for the first time avoided a conviction. And that is my goal for every single client. So let's jump right in. Your lawyer tells you to take the case to trial. This is before you have been to court even one time. And at first, that sounds like a relief, right? You're thinking, good, I didn't do this. These are false accusations. I'll finally get to clear my name. Maybe, in your case, you're also thinking, the victim is on my side. They're not going to testify. The state cannot prove anything anyway. Trial feels like the path to justice, right? And your own lawyer is recommending it to you. But then something in your gut starts whispering, wait, is this really the best move? That hesitation, that tiny voice, that might be the thing that saves your job, your record, and your future. And what's been bothering me and what made me sit down and record this video is how often people here take it to trial before they've ever been to their first court date. Let me explain why that's a problem using a simple example. Dan gets arrested after a heated argument at home. He has no prior record, there are no serious injuries. He bonds out and he gets a court date for 3 weeks later. He hires a lawyer the next day and he explains to the lawyer that he didn't do this. The lawyer immediately says, don't worry, we're taking this to trial. That sounds strong. It sounds confident. It sounds reassuring. But here's what has not even happened yet. No one has called the district attorney, the prosecutor. Prosecutor is the one who's in charge of deciding whether or not to file charges in the case. Nobody has tried to stop the charges from being filed. No one, including the attorney, even knows what's actually in the police report, what the alleged victim said to the police, what evidence actually exists that led the police to arrest Dan. Nobody has seen it yet. 2 weeks later, the district attorney filed charges that might never have been filed at all if someone had intervened early. Now, Dan has a criminal case against him, a protective order, and a real risk to his career and his future, all because his lawyer skipped some of the most important steps, including the step before court to contact the district attorney and try to get the case dropped. That is the first reason that this is a red flag. I'm just going to be brutally honest here. If your attorney is pushing for trial before even stepping foot in court, you haven't gone to court, they haven't gone to court, they're either reckless, lazy, or trying to manipulate you. Because at that point, before anybody's been to court, before anyone sees the evidence, they don't even know if there's going to be a case. A good attorney contacts the DA before that first court date. They try to stop the case from being filed entirely. They try to do everything possible to protect you from the risk of trial, a lifelong conviction, or even jail or potentially prison time, depending on the case. Because if there's no case filed against you, if they intervene and they're successful, you win. There's no court, there's no conviction, there is no record. That is better than winning a trial because it happens early. That's freedom before the fight even starts. Now, let me show you, again, brutal honesty here, how this sometimes plays out when a lawyer pushes for trial early on. Let's stick with Dan for our example here. After Dan's lawyer does not call the DA and charges get filed, now it really starts to feel real to Dan. He's going to court every month. He cannot sleep, he's being treated like a criminal, and he's starting to feel like one. He is terrified, and that's when the lawyer says, okay, now we need to prepare for trial, and hits him with a massive trial fee. Months go by, trial gets closer, and suddenly the tone changes. Now the lawyer says, well, maybe we should consider a deal. Dan is out of money, exhausted, scared out of his mind, and feels boxed in. He takes a deal that he could have gotten, or maybe avoided entirely, much earlier. That is not a strategy. That is setting someone up. I mean, it's not unless and until a case actually gets filed that you get body-worn camera footage showing exactly what was said, photos of any alleged injuries, 911 calls, witness statements. So how can anyone honestly say this should go to trial before you have any of that, before you know the chances of success at trial? That is not competence. That is irresponsibility. And again, brutal honesty, manipulation in some cases. Even if the alleged victim is on your side, you have to remember that you don't know exactly what is in the evidence yet. Now let's go back to Dan. We'll change some of the facts here for a fictional but very realistic example of why that happens. Let's say that Dan's partner later tells him, "I never wanted you arrested." But on the body-worn video taken minutes after the incident, which again you do not get until you go to court unless and until charges are filed, she's crying, she is shaken, and she's describing events very differently. Those early statements that she made under stress often carry far more weight than what she says months later. So even if the victim is on your side, even if your attorney knows that, relying on "they're on my side" is dangerous when making decisions about how to handle the case. I want to be very clear here. I'm not anti-trial. I'm a trial attorney. I've won difficult trials, but trial is a last resort because of the risk. You do not go to trial to clear your name unless you fully understand the risks, you have no better option, and you have tried everything else, because trial is stressful, it is expensive, and it's unpredictable. No matter how good your attorney is, you're sitting in front of 12 strangers, people who, like you before all this happened probably, have never been arrested, asking them to decide your future. Well, let's go back to Dan and see what might have happened if he went to trial. Dan knows that he didn't hurt anyone. He knows that he's innocent, he did not do anything wrong. But at trial, the jurors see the body-worn video of his partner crying, with a red mark on her arm that the prosecution says is an injury caused by him. A neighbor testifies. Again, they didn't even know about the neighbor until they went to court for the first time, maybe even the second time, and got that evidence. The neighbor testifies and says that she heard an angry man's voice yelling and heard a thud on the wall. The prosecution puts on an expert witness who testifies that even though Dan's partner is on his side now, she's obviously a victim of battered women syndrome. And the jury, looking at all of that, seeing Dan sitting in the defendant's seat next to his lawyer, hearing the horrible things that the prosecution is saying about him, decide that they think he did it. Dan's lawyer, to his credit, he does his best, but the jury sees that all of this looks bad, and they vote guilty. Now Dan has a lifelong conviction, and the judge will sentence him potentially to jail, prison, or years of probation. For a lot of my clients, a lot of people like Dan, when it's their first time ever being arrested, they never thought that they were going to be in the criminal justice system. When you call an attorney, when you hire an attorney, you trust their judgment. They're the expert, just like you are the expert at your job. But it's important that you educate yourself so that you are not choosing trial just because you were angry or embarrassed, or someone told you you didn't do it so you should fight, or even your lawyer telling you early on, "We're taking this case to trial." You need to make sure that you are making a strategic decision instead of an emotional one so that you can protect yourself. So what should a good attorney be doing instead when you hire them after you get arrested before your first court date? If someone like Dan called my office, here's what I would look at before ever talking about trial. First, can we get the case dropped before court? Can we present information to the DA that makes them decide not to file charges at all? If we can do that, Dan can put this whole thing behind him early on. He does not have the stress. He does not have the expense of trial. He can sleep well months, sometimes years earlier. Second, if charges are filed, can we get the prosecution to dismiss the case? Can we get him a diversion program? Can we get him classes in exchange for a dismissal? Can we file a motion to suppress evidence? Only after all that, if the evidence is weak and if the DA still will not budge, and they are offering someone like Dan a conviction, something that is going to potentially ruin his life, do we talk about trial? Trial should be a strategy, not a reaction. And here's something that most attorneys will not say out loud. If I were charged with domestic violence, even if I were innocent and the DA offered me classes with a guaranteed dismissal, I would take it. I would do everything in my power to get that offer, and if I got it, I would take it. Not because I'm afraid to fight, not because I'm afraid to go to trial, but because I know what a conviction would do to my life. I know the risk of trial, and I know that if you lose, you get a conviction. And that's what's at stake for people like Dan, and maybe what's at stake for you, your career, your professional license, your reputation, your family. So yes, I personally would swallow my pride to avoid a permanent record that was going to ruin my life. But on the other hand, if I could not get that offer, if the offer was going to be a conviction, and trial was the only way to protect my future, after looking through all the evidence, after trying everything I could possibly do, then yes, I would go to trial, and I would fight with everything I have, but only then, after I'd exhausted every other option. So, if your attorney is already pushing trial, before reviewing the evidence, before calling the DA, before trying to stop charges from being filed, you need to pause and ask yourself, is this real strategy or am I being set up? Because when it comes to your future, your freedom, your record, you do not get a do-over. So ask questions and demand clarity. I hope that you found this video helpful. If you do have a domestic violence criminal case in California, feel free to book a call with my office. You can find a Calendly link down below. You can also find our phone number there. And if you did find it helpful, please don't forget to like, subscribe, ring the bell, and if you have a question or a comment, leave it in the comments.